Okay, so I think we'll begin. My name is Lucy Horsefield. I'm the UK Director, and I'm really delighted to be welcoming so many of you here today for our webinar on the key proposals from the UK Government's Immigration White Paper. I'm just going to introduce my colleagues here and our guest speaker. Just go on to the next slide, Adam. So we're delighted to be joined by Adam Pipe, who is a barrister specialising in immigration law, asylum and human rights. And he's our guest speaker today from number 8 Chambers. And I'm also joined by Emran, who is the head of Middle East and Africa at LanguageCert. Just to give you an overview of what we'll be talking about today. So first of all, I'm just going to give you a very brief introduction because we do have quite a lot of people joining us for the first time, which is fantastic. Then I'll hand over to Adam for the meat of the webinar, and he'll be going through a lot of really useful, interesting information about the proposed changes. And then Ozzy will be talking to you about the SELT offering and the products and the ways that we can support you and your clients. At the end, there will be an opportunity for Q&A. You can see the Q&A box at the bottom of the screen. But also, those of you that submitted questions prior to the webinar, Adam has tried to incorporate some of those into his slides. So just to give a little introduction to LanguageCert for those of you that are new to us, we're part of the PeopleCert group, which is a leader in language assessment and also professional certifications, products such as Prince that you may be familiar with, the project management. And our exams are regulated by Ofqual, and we offer products for study, work and migration purposes. You can see that we're members of many important global and regional national bodies, for example, ALTE, for the Association of European Testing. And we also offer high stakes tests, which are trusted by 2,500 education institutions and governments, as well as UK BI. On that note, we've been offering secure English language tests since 2019. And also we work with lots of higher education institutions. Our exams are accepted by the majority of UK universities, also many countries around the world. We have study visas in Ireland that the exams are used for, and also higher education applications in New Zealand. And we have growing recognition across North America. So we will tell you a little bit more about LanguageCert and our exams after Adam has spoken. But for now, I'm going to hand over to Adam and say thank you very much for joining us. And over to you, Adam. Thank you.
Brilliant. Thank you, Lucy. And thank you so much for everyone who's joined us today. I know we've got people joining us from around the world. We've got about 400 people registered. We've got immigration lawyers here in the United Kingdom. We've got visa agents abroad. We've got students, people who want to come to the UK, lots of different people. So I'm going to try and provide something for everyone today as we look at the white paper. Thank you so much, LanguageCert, for hosting today. Lucy and Ozzy, for all your hard work in preparing today. It's a real privilege to be here with you to talk about the government's white paper from the 12th of May this year, restoring control over the immigration system. And even in that title, we can see the sort of intent of the government. So I'm going to do this morning in 3 parts. I've got 30 minutes. I'm going to try and be good and stick to my time. Do post any questions in the chat. I've got a couple of emails with some different questions that have been submitted. I'll try and incorporate those as we go. But in part 1, I'm going to give some headlines. So for those of you who just want to get a hold of what are the changes, part 1 will help you simply understand what changes are on the way, or what are the proposed changes, because nothing is set in stone yet. In part 2, I'm going to go into more detail. So for those of you who perhaps are immigration lawyers or advise people, or just want some more information in order to post on your social media, to put in your email newsletter, to provide information to potential clients, we'll go through the actual white paper. And as an added bonus today, I'm going to look at what also the Migration Advisory Committee has recently said in relation to the financial requirement for family visas. So anybody who works in the area of family visas, we'll have a look at what the Migration Advisory Committee has said. And then finally, in the last few slides in part 3, I'm going to look at what is the potential impact and what steps do we need to be taking now, whether you're an employer, an educational institution, a potential migrant to the United Kingdom, or an immigration lawyer. What steps do we need to take now? I also want to provide you with some free resources. So if you click on the link or scan this QR code now, you'll get access to my Telegram channel, my WhatsApp channel. I know some people forget to click join. So when you click on the WhatsApp channel, don't forget to click join. There's lots of free videos. There's a PDF summary of the white paper. Lots of resources available there that I wanted to make freely available. So do make use of those, and I hope they're helpful to you. So let's have a look at the headlines. You know, at the beginning of every news broadcast, there's the headlines. So here's the headlines from the white paper. So the key proposals are aimed at reducing net migration, prioritizing skilled workers, ensuring fairness, enforcing rules, and promoting immigration. I've created a summary of the white paper, and there's a link to get that. And I should say, I think LanguageCert will send out a copy of my slides. So if you need to use this material or go over it, my slides I've made available so they can send them out again to provide added value to you. So for those of you interested in work routes, there's going to be a higher skilled threshold. We're going from RQF level 3, which is A-level equivalent, to RQF level 6, bachelor's degree equivalent. The government aims to say, well, we only want sponsored workers to be doing graduate level jobs. Along with that, salary requirements for skilled worker visas will rise. There's going to be an end to overseas social care recruitment. So there's a transitional period where this will be allowed up until 2028, but then they're proposing to stop social care recruitment after that time. And there's been a number of changes for those coming as care workers and senior care workers over recent years. They're going to abolish the immigration salary list and replace it with a temporary shortage list. The temporary shortage list, as you'll see on this slide, will only offer time-limited access to the points-based system for jobs below RQF level 6. And it'll need to be approved by the Migration Advisory Committee, and there needs to be a proper workforce strategy in place. There's going to increase the immigration skills charge, so the amount employers pay will go up by 32%. Sectors have to now have in place workforce strategies. We are going to see some refugee employment, although this is going to be a limited number through UNHCR recognised refugees. There is some positive news. I don't want everybody to think it's all bad news, but there is going to be some expansion to the highly skilled routes. And for those of you advising people, or for those of you looking to come to the United Kingdom, you might want to think, actually, is the highly skilled route a better route for me or for my client? Student routes, I'm sure a lot of you are interested in that today. One of the big headlines is the reduction in the graduate visa, which is at the moment 2 years, obviously wider 3 years for those with a PhD, being brought down to 18 months. Stricter sponsorship requirements for universities and colleges sponsoring international students, and a red, amber, green system based on how well they're doing in their basic compliance assessment. The government is also thinking of introducing a higher education levy. So we might see costs go up in relation to that. The government are also looking at family immigration, and they're looking by the end of this year to revise the family immigration policy. They're going to make suitability requirements, good character requirements, stricter. They're now introducing English language requirements for dependents. And I know Ozzy's going to talk about English language requirements and how LanguageCert can help you. Well, this is important because for the first time, there's going to be English language requirements for the dependents of workers and students. They're also creating a bereaved parent route. We've got bereaved partner already. They're creating a bereaved parent route. One of the other things to hit the news is this longer route to settlement. There's going to be a move from the normal 5 years to 10 years. Can I just pause? Actually, I just posted on my social media, on my Telegram group and my WhatsApp, a petition. So somebody started a House of Commons petition to keep the settlement level to 5 years for skilled workers. So have a look at that, and you might want to sign up to that petition. I posted it on my social media literally about 10 minutes ago. But there is a chance to get to settlement quicker by earning settlement. There's this whole new concept of earned settlement and earned citizenship by contributing to the economy and society. So if you advise migrants, they need to perhaps keep evidence of any work they do that benefits society, because that may help them get to settlement quicker. They're emphasizing integration, and in terms of the English language requirements going up generally, we'll cover that, and the Life in the UK test being refreshed. Now, I just want to pause before we get into things. The white paper is not yet law. For those of you who don't know, a white paper is an official policy document that presents the government's detailed proposals for future legislation or policy changes. It's one of the key ways the government communicates its intentions to Parliament and the public. Now, these are specific and it's very detailed, but at the moment, they are proposals, not law. So a number of the questions that LanguageCert have forwarded to me, so somebody said, when are the changes coming into force? Well, we don't know. There is no fixed date for implementation. Some will come in soon, but others will require consultation. They might require public consultation with evidence input, and the government have created or going to create a labour market evidence group where they may have to contribute. So some things will take a bit of time and may look different actually when they come into force, but those affected need to know what's coming. So it's worth, for those of you advising people or helping people with applications, need to know what's coming, need to promulgate this information on your social media, through your email marketing. And hopefully today's webinar will help you develop marketing strategies and hopefully increase the work that you guys get. So it's important for people to be prepared. So for some people, preparedness will be starting to get sorted with their English language qualifications, which LanguageCert can help you with. For some people, you might think, actually, because the rules are going to change, we need to get ready to make an application now before the plan changes. So for immigration lawyers, are there clients who may be caught out in the future that you need to give them the nudge to apply now? But this is about being prepared and knowing what's coming so we can advise our clients, we can be as effective as possible. So part 2, let's get into the heart of the white paper. I'm going to try and cover this in 10 minutes or less. So here we go. These are extracts from the white paper, and I want to provide these for you so you can cut and paste from them and use them to get this information out and to go over them in your own time, because I could probably spend 3 hours with my slides, so there's plenty here. But this, the government's intention is to restore confidence. They want to support the benefits of migration, but properly controlling it. And at paragraph 27, they give a summary of the headlines I've just gone through. Now, they're concerned about increasing overseas recruitment and a reduction of investment in skills and training in the United Kingdom, and a rising level of unemployment and a lack of economic activity in the UK. So they're going to establish a labour market evidence group. They're also going to require those sectors that want to recruit from abroad have a workforce strategy in place in order to take steps to engage the inactive domestic labour force. Now, this is an important point to pay attention to. So as I said earlier, skills level going up to RQF6 degree level, salary threshold will rise, paragraph 68. Look at paragraph 69. We're going to see a reduction by about 180 eligible occupations as a result of this change. But for those people already here as a skilled worker, or for those people who apply for a skilled worker now before the changes come into force, there are transitional provisions. So paragraph 71, in relation to those already utilising the skilled worker visa, from the point that the skills threshold is raised, existing skilled worker visa holders will continue to be able to renew their visa, change employment, and take supplementary employment in currently eligible occupations below RQF 6. However, applicants from overseas or those applying to switch from other routes will have to follow the new rules. So that's important to remind people that there are those transitional provisions. This is the paragraph that, or the paragraphs that deal with the temporary shortage list, where there will be a time-limited permission for lower skilled levels to then bring people over. So, but again, subject to MAC, subject to workforce strategy. Now, as I've said, there's been a concerted effort by the government in relation to social care visas and the carers and senior carers. So the previous Conservative government, from the beginning of last year, stopped them bringing dependents. There was a change this year which required people to recruit from the existing pool of workers in the United Kingdom who'd come here on visas, but perhaps their sponsor had lost their license or they were abusive employers. Now what they're saying is they're going to end overseas recruitment for social care visas in line with our wider reforms to skill threshold. We will close social care visas to new applications from abroad. For a transitional period up until 2028, we'll permit visa extension and in-country switching for those already in the country with working rights, but this will be kept under review. So if you are somebody who employs people on care visas, if you advise companies who do, you're going to need to look and work with them to think about their recruitment strategies going forward. I talked in my headlines about refugee opportunities. Well, what they're going to do is explore reforms to allow a limited pool of UNHCR recognised refugees and displaced people living overseas the opportunity to apply directly for jobs and visas to come to the UK through a new displaced talent mobility scheme. But look, that only applies to those overseas who are recognised by UNHCR, so quite limited. As I said, the immigration skills charge is rising for the first time since its introduction, paragraph 85, and it's rising by 32%. Let me just give you the numbers. For medium and large firms, it's going up from 1,000 to 1,320. For small firms or charities, 364 to 480. Let's give you some good news. These are the changes in relation to the highly skilled. So this is something you need to start exploring, either if you want to come to the United Kingdom or you're advising people. But the difficulty again is I think this will impact smaller numbers. So they're going to increase the number of people arriving on our very high talent route, alongside faster routes for bringing people to the UK who have the right skills and experience to supercharge UK growth in strategic industries. As part of that, increasing places on our scheme for research interns. That's the government authorised exchange scheme, including those working in the field of AI to allow businesses to access additional promising young talent. Make it simpler and easier for top scientific and design talent to use our global talent visa. So that's good. Review our innovator founder visa to ensure that it supports all entrepreneurial talent currently studying at UK universities to move into the visa so that they can build their businesses and career in the UK. So there may be some pathway for those coming over as students to switch then into the innovator founder visa. So that's something to keep on your radar. Double the number of workers that an overseas business can send to the UK with the aim of establishing a presence in the UK. So that's the UK expansion worker. When it's doubling, it's going from 5 to 10. We will explore a targeted and capped expansion of the high potential individual route, looking to double the number of qualifying institutions. So this is universities around the world. People who've graduated from various universities are coming as high potential individuals. So that's a positive potential while maintaining the focus of the route on individuals that will have the most benefit to the UK workforce and ensuring that any necessary safeguards are in place. Here's the changes they're making in relation to student visas and the requirement. So they're raising the minimum pass requirement of each BCA. They're introducing this red, amber, green banding system to the BCA performance of each sponsor. New interventions for sponsors who are close to failing their metrics, including placing them on a bespoke action plan. So if you're an educational institution in the United Kingdom or you work with them, you're going to need to make sure that they've got their compliance nailed on. Require all sponsors wishing to recruit agents for overseas students to sign up to the agent quality framework. So if you're an agent on the call today, that's something you need to be aware of. Also, sponsoring institutions need to consider local impacts and then evidence of a genuine student and accreditation bodies to ensure that their processes are robust and consider what further checks need to be put into place to ensure that the right level of scrutiny is being applied before an organisation is accredited and when that accreditation is renewed. Paragraph 127 relates to short-term study. So paragraph 127 relates to short-term study. Here's the change with the graduates. It seems to be across the board. Graduate visa being reduced to 18 months. So it seems to be there's no extra now for the PhD, but the graduate visa is being reduced to 18 months. Somebody asked, is it possible let me look at the question. Is it possible to apply for a Tier 4 visa for a postgraduate course while in the UK with a graduate visa? I think it is looking this morning. Do take specific advice, but I did, when I saw that question, look at Appendix Student, and it doesn't seem to rule out in the eligibility requirements people with leave as a graduate in the United Kingdom. So that seems to be permitted. And then potentially, I think they're asking, could you go back on the graduate visa again? Again, it doesn't seem to be ruled out in the appendix graduate, but obviously changes are being made and this is being tightened up. So do look at that in the future. The Russell Group, so the leading group of universities in the United Kingdom, are concerned that this will make the UK less competitive, because the graduate visa makes the UK attractive for students to come to the United Kingdom. So this is what the Russell Group has put out, and this is something, if you're doing any lobbying work, you may want to refer to. There are also concerns in terms of the levy on international student income that is going to be put into place. So these are the concerns that the Russell Group have voiced as a result of these changes. The government are also targeting family migration. They're concerned about family migration and specifically about cases that are accepted on an Article 8 or exceptional grounds. And look at these changes before the end of the year. So this is coming soon. So if you've got applications that need to be made before this, do that. They're going to set out a new family policy that will cover all UK residents, including those who are British, settled on work routes or refugees seeking to bring family members to the UK. So I think we may see an expanded version of Appendix FM. I don't know what it'll be called, but it seems it's going to be an expanded, all-encompassing. Clear relationship requirements, because they're concerned about forced marriage and domestic violence. Look at this. I'm sure this is of relevance. Ensure those coming to the UK have an appropriate level of English language skills to be able to effectively integrate into local communities. Ensure the family unit has sufficient money to financially support any migrants without relying on the taxpayer, and they're going to review the financial requirement. And as we know, they had referred to MAC, the financial requirement. They're also exploring tightening suitability requirements. So this is what MAC produced their report on the 10th of June. I've put the links because I'm just going to skip through this because of time. But if you're involved in family visa applications, as you know, in 2012, it went up to 18,600. Unless you're on some sort of benefit where you're on the adequate maintenance requirement. The Conservative government proposed to bring it in line with skilled workers, with the idea of bringing it all the way up to 38,700, but they brought in the first stage of 29,000. So the family income requirement is now 29,000 with no additional amounts for children as there was previously. This has been referred to MAC. They've produced their report. There's also a letter from Professor Brian Bell, the head of MAC, to the Home Secretary. They propose different options, 4 different options, depending on how you want to calculate the finances. But what they suggest is reasonable measures fall in the range of 19,000 to 28,000. And a lot of the figures they've looked at end up falling between 23,000 to 25,000. So that's in fact lower than the current 29,000. So they don't see that it should be linked to the skilled worker requirement. They say this is different to the skilled worker. They also think that the government should take into account the non-UK applicants' potential earnings. So that's something they want to have a look at. They're also concerned about the current adequacy of maintenance test for those on benefits. So what I've done, I've gone through the report, I've taken out the key paragraphs and I've highlighted the key bits. So there's the region that they've said, potentially a higher if you want to go on having a positive impact on finances. But they say that this means the sponsor income is not an accurate way to predict the impact of the partner on broader measures of economic well-being for the country as a whole. They don't think there should be a regional variation. So they don't think you'd have to earn more if you're living in London. They do not recommend an additional amount for families with children. And they're not convinced that the current system sufficiently takes into account the negative effects of separation on British children. They also are concerned about the current state of the adequacy of maintenance test, the AM test. So I've put that there, and they do not think, as I've said, it should be linked to the skilled worker financial requirement. And that's very good news. I'm just going to skip that, and you can have a look at that in your own time, because I know for some people this will be relevant, for others not so relevant. What they do say at the very end is, look, this increase that happened was large and unexpected. So the government shouldn't wait for years and years and years and all of a sudden massively increase it. They should be regularly reviewing annually to see if the level is correct. So that's positive, because this massive change from 18,600 to 29,000 was such a shock to so many of our clients. Let's go back to the white paper. So they are targeting Article 8 human rights in exceptional circumstances, and they want Parliament again to set the boundaries in terms of Article 8, paragraph 152, and how the balance should be struck. So whether we'll see an actual definition of what is unjustifiably harsh circumstances, for example. They're concerned about people coming on visitors and then trying to stay on family relationships. They're concerned about people trying to frustrate removal. They're also now going to clarify what cases are treated as exceptional. They're going to bring forward legislation. So that looks like primary legislation, paragraph 156. They want to continue things like community sponsorship scheme, like we've seen in the Homes for Ukraine scheme. And they're going to reform the sponsor system. And that's good for workers, because a lot of workers have been exploited. So they say this will include exploring making it easier for workers to move between licensed sponsors for the duration of their visa, giving them more control over who they work for and reducing the risk of exploitation. They're tightening on enforcement, so be aware of that. I'm not going to go through this, but they're really, and we've already seen this with sponsor license revocation, targeting illegal working with the current government. They are targeting enforcement very much. Now, here's the important bit in terms of English language. So wake up anybody who's gone to sleep. This is the important bit. We will increase the language requirements for skilled workers and workers where a language requirement already applies from B1 to B2. And I know Ozzy can talk more about this in accordance with the Common European Framework for Reference for Languages. It is important that we ensure better integration and consistency in our requirements of family members across the immigration system. So we will introduce a new English language requirement for all adult dependents of workers and students at A1 level, basic user, to align to the spousal and partner routes. And we will work towards increasing this requirement over time. So that's something we need to prioritize in people getting English language tests or start learning now. We want individuals to improve their English language skills over time as they continue their stay in the UK. We will introduce requirements to demonstrate progression to level A2 for any extension and B2 for settlement. So maybe if you're an employer in the United Kingdom, you need to work with people to make sure they're getting that English up to the right level. We'll increase our existing requirements for settlement across the majority of immigration routes from B1 to B2. I've looked at some articles I read, and people think these changes in relation to, because a number of the questions asked about this, changes to English language could come in 2025, 26, so maybe even later this year. I don't think there needs to be any huge consultation before bringing this in. So this is something, a change we could see quite soon. So this is something really to be aware of and to reach out to LanguageCert if they can help you with this aspect, which is obviously their expertise. Now, this is the earned settlement and the moving from 5 years to 10 years, but be aware, 265, a shorter pathway for non-UK dependents of British citizens to 5 years to remain compliant with who remain compliant with their requirements. So partners of British citizens, still 5 years. Interesting, it doesn't say partners of settled people. So if you're entitled to British citizenship and you've got your partner here, get your British citizenship because that could help with that. Again, they talk about a shorter path for those who contribute to the economy. So make sure you're paying your taxes, make sure you're earning as much as you could, and contribute to society. If you're doing community work, keep evidence of that, because that's something that could affect your settlement in the future. They're creating this bereaved parent route and also going to look after children who turn 18 and discover they don't have status. Then again, we're going to see this earned citizenship as well. So there's no further details about that, but be aware of that, and they're refreshing the life in the UK test. Again, I don't know. Let's go back to the settlement. One of the questions was about transitional provisions. I don't know if it'll impact those already here. You would hope it would only impact those who are now coming on the sort of new visas and they're subject to the new settlement requirements. There's nothing there in relation to transitional provisions. So we need to make ourselves ready and be prepared that this could impact people. So for those who qualify for settlement, make those applications now. I think I've got about a minute left for my part 3. So let's look in, and I've tried to weave this in, the impact and the actions. But let's look at the impact. Obviously, there's going to be higher barriers to entry in terms of higher skilled thresholds and salary requirements, which make it harder for low and medium skilled migrants. There's going to be this longer path to settlement, which is increases uncertainty. And we all know the cost of continually having to make applications to the Home Office. There's reduced student benefits, so the shorter post-study period and the levy. We've already seen what the Russell Group said in relation to that. They're going to tighten up enforcements and tighten up family life and what's considered as exceptional circumstances. If you've got a case that falls potentially outside the rules into exceptional circumstances, make that now. There is a positive note on the highly skilled routes. So for some people, that's a route you may need to consider going down. There's going to be challenges for employers in terms of recruitment, especially in care, hospitality and construction, potentially huge costs, an increased cost involved, and a loss of flexibility with the ending of, we had the shortage occupation list previously, and now we've got the immigration salary list, and now we're only going to have this temporary list. And an uncertainty in terms of labour planning. Specifically, there's concerns in the area of social care And I think in universities as well, there's going to be concerns that we need to be aware of. So finally, what then do we need to do? Check your eligibility early. So are you eligible now? Should you be applying now? Are you going to be affected by changes? Should you go down other routes? Prioritize English proficiency. I've highlighted that because we're on a LanguageCert webinar. So that's something obviously LanguageCert and Aussie can talk to you about, but prioritize for dependents or for those coming or for those wanting to stay English language. And if your employer, work with them. Consider timing your applications. Should you be making applications before the different rules or thresholds are implemented? If you're an employer or if you're a lawyer today who works with employers, audit workforce needs. Strengthen domestic recruitment, because this is all, it's carrot and stick. It's rooted in sort of increasing your domestic recruitment to give you that flexibility then to be able to recruit from abroad. Sort out your compliance issues. Make sure you're compliant with your sponsor obligations. Then engage with policy consultation. When the government puts it out to consultation, make your representations. I've already talked about that petition today, but these are the sort of things to get involved with. And for educational institutions, strengthen your compliance because they're focusing on that. Maybe think about diversifying your recruitment markets. Are you very dependent on markets that are very sensitive to visa policy? And then increase your support for students, whether it's helping them with their English language element or it's helping them gain employment that might help them get onto a different route in the future. I know in just over half an hour, and I apologize, I'm 2 minutes over. I've covered a lot of ground there and there's a lot to go through. So I'd encourage you to go through my notes, get those resources, but I'll hand over to back to Lucy. Thank you so much, everyone.
Thanks ever so much, Adam. I think you covered a lot there, very, very capably, as I would expect, in fact. Thank you. So I'm going to just hand over to Ozzy now, who's just sharing his screen. And over to you, Ozzy. Thank you.
Yeah, thank you very much. Welcome again to our CELT webinar, which is a regular sort of like online event for our audience, our partners, and especially in this case, many immigration lawyers. Again, I would like to thank Adam for his comprehensive review of the proposed changes in the white paper. He highlighted a couple of points, especially around English proficiency, where LanguageCert can definitely play a critical part in your services for your clients. Just to sort of like just to sort of like reiterate, LanguageCert sort of like exams are providing the English language requirements needed for family spouse visas, work permits, and student visas. It is one of the CELT exams that can be taken inside the UK and outside the UK, actually. So it is available for our international network of partners as well as the UK immigration lawyers. And there are two-faceted exams needed for family spouse visas, settlement purposes, and British citizenship. But there are four-faceted exams which are needed for work permit applicants and student applicants. And here you can see really the table that shows each level needed for each sort of like a UK visa application. So, a spouse visa from application from outside the UK would need to take an A1, sort of like a CELT exam, which is a basic user according to the Common European Framework. As Adam just explained, in the future, the UK government proposes that the dependents of the skilled workers would have to take the A1 CELT exam as well. Now, right now, the dependents of the UK skilled workers do not need to take an exam, the adult dependents, but the white paper proposes this particular change. This is a entry level sort of like proficiency. Another basically change, this is basically showing the existing levels required for the UK visa applications. But again, as Adam just explained, any sort of like English proficiency that requires the B1 level is proposed to be increased to the B2 level. So according to the Common European Framework, the B group of levels are independent users, but a B1 is just the threshold of the independent user, actually. But the B2 level is quite a significant sort of like improvement according to the global language cert scale. That is a 20 point extra out of the 100 on our scale, actually. So you can appreciate that this is quite a significant improvement for the candidates. Obviously we are here to help you with this, with this particular challenge. Just to sort of like explain that Language Cert is obviously available in more than 20 centers across the UK with a very high availability, and also in numerous locations in India, Iraq, Pakistan. These are sort of like the highest number of SELT applicants, basically. We have, many sort of like test centers here where your clients abroad can take our sort of like a SELT exam for their English for their UK visa applications. I mentioned that we can provide you a solution to the increase from B1 to B2 in particular, and also obviously the new requirement for dependents like A1. These are the free preparation resources for all levels actually available. So, you are more than welcome to actually visit our website and access the official practice papers, the various videos, familiarization videos and sample test videos, preparation tips. But I really would like to sort of like, highlight especially the exam simulation tool that we have that is available for the Language Cert General and Language Cert Academic exams. These are typically for skilled workers or like students. And this is a fantastic tool where your clients can actually experience the exam for free, can get some sort of like feedback about how they're doing, about their performance, and ensure that they prepare very well. Also, what is coming soon is we also have an interactive practice test bank that will work together with the candidate, self-study mode, obviously, to ensure that they develop their language skills and become proficient and hopefully pass the exam. So whilst we provide these preparation resources and all the support for your clients, you can also obviously benefit from our partnership, which is very easy. There is no setup fees, there are no hidden costs, and it is a typical sort of like a registration referral partnership where your candidates can actually receive a 10% discount from the standard fee, and on top of that you can earn a referral fee from this partnership. All you need to do is really to promote a unique code that is just for you in your social media, in your website, in your emails, and whenever anybody actually uses that particular unique code, will receive a discount, and you as your firm will also be eligible for a commission. But as an organization, if you are against actually receiving commission, we can still offer the discount to your clients, actually. There are obviously other partnership opportunities. These are for more serious sort of like, English language providers. If you do have the facilities and the personnel outside the UK, actually, you can become a UKVI approved SELT center. We call them high stakes test centers. This will enable you to actually provide a one-stop shop for your clients. If you are, let's say, in the UAE or in India, you provide your immigration service to your candidate, to your client, but they can actually take the exam at your premises if you meet the requirements. There is also the approved test center partnership model where you can, administer ESOL exams. And also, we already mentioned the referral partnership scheme, but then you can also actually distribute the vouchers, the SELT vouchers, with a profit margin. So we are able to give you discounts on SELT vouchers outside the UK. Again, this is not allowed in the UK. In the UK, we can only provide registration agreements. Outside the UK, we can provide you a voucher agreement where you can actually resell these discounted vouchers. And here are really a couple of sort of like notes why we are really different from the other SELT providers. We provide immediate preliminary results, especially for the speaking and listening test. This is a great service. Your client will know immediately if they need to retake the exam. They don't need to wait for a week or 2 weeks to know the result and then rebook again. Booking up to 24 hours is amazing. But then again, the speaking test is with a real person actually online. It's not like physically face to face, but it is remotely administered live with one of our interlocutors, which is also preferred by many candidates across our network. And we also provide a free retake option for the speaking and listening test, which has a limited time offer. So these are the things that are very attractive when it comes to LanguageCert. We will share these slides, obviously, but here is sort of like our global organization. You already met Lucy. She is the director for the UK. I am responsible for Middle East and Africa, and our director for EMEA and Americas is Henry Tolley. So please do reach out to us if you would like to partner with us, actually. And I would be more than happy to work with you or direct your interest to the relevant sort of like a team. And this will basically lead us to the Q&A session. So I would like to thank you again, and let's go through the questions that you might have.
Thank you very much, Ozzy. Just looking at the questions, I think there's some interest in this change in the RQF level to RQF 6. Is that the correct term, Adam? In terms of the occupation list.
I've had a look at the question. Somebody cheekily asked, will a solicitor be removed from the...
Yes, that was the question that I saw.
I didn't know if that was joke of the day. I thought, so what I was going to say is I presume a solicitor would be a graduate level job, so wouldn't be removed. So at the moment, the proposal is to remove those jobs below RQF level 6 and then have a temporary access to jobs below that level. Let me just also say, because it was a couple of things I realised while Ozzy was talking that I didn't cover in the pre-submitted questions. Somebody asked about e-visas, a bit off topic, but obviously clients have had to transfer to e-visas. Somebody asked about cost. There's no cost in e-visas. I don't know if they're mixing up with what's called electronic travel authorization. So now, if you're a non-visa national coming to the United Kingdom, you have to have an electronic travel authorization, and that costs £16, and you just do it on an app, and it takes minutes unless you've got issues, perhaps criminal convictions in the past. So that's something. Somebody also asked about studies counting towards the 10-year duration for settlement. Obviously, a student visa is not a route to settlement, but you can count at the moment time as a student towards long residence. I can't see that changing because, you know, the universities, you know, and people then go from studying into skilled worker. So you would have thought that student visas would always be able to count that time towards settlement. It does now. Obviously, I can't say what about the future. I've actually got the chat box, the Q&A box open in front of me, Lucy, and I can see a question about asylum. Let me just jump on that. There wasn't much in the white paper about the asylum, only about the displaced talent. Somebody asks about concerns about changes affecting LGBT plus asylum seekers and also asylum seekers from Pakistan. Clearly, because of the ending of the Rwanda scheme, the government is now with a huge backlog on asylum, and there has been an announcement that the Home Secretary is planning for a dedicated fast-track process for immigration lawyers who are still on the webinar. Clearly, that fast-track processes have led to a lot of litigation in the past. Now, you would have thought somebody who's a genuine LGBT plus asylum seeker wouldn't be subject to fast track, but do have a look. There's a news article that came out on the 6th of June on EIN entitled Home Secretary Signals Plans for Dedicated Fast Track Process for Asylum Seekers from Safe Countries. So just be aware of that. Nothing more in the white paper, but clearly the government are going to have to try and clear this backlog. Just as an aside, I am seeing more cases now being withdrawn by the Home Office with a view to grant at appeal stage. So I know that would never be announced officially as some sort of amnesty or backlog clearing exercise, but that seems to be going on. Lucy, had you spotted any other questions that we could deal with?
No, I think the common point, which is fantastic, is that everybody's found you know, the content that you provided very useful and would really appreciate a copy of the slides,
yeah.
Which I know you mentioned, you know, we will share. Also, did you want to just flash up again, Adam, your actually, no, we can't do that. I've just realised it's not.
It'll be on the slide.
We'll share it. It will be on the slides.
Anybody who has the slides, we'll send out the PDF. And if you just get your phone for the technologically challenged, turn the camera on, aim it at that QR code, and a yellow link will appear on your phone. Click on that, and then you can get access to all my videos. I've done other bits and bobs on the white paper and changes, recent stuff coming up, articles, because I appreciate we've crammed a lot into this hour. And there's a lot. Somebody says the Linktree WhatsApp isn't working. I'll make sure I refresh that because somebody said that to me. So I'll refresh that now straight after to make sure you can get access. But if you search on, I know in WhatsApp, if anybody uses WhatsApp channels, if you search, let me see what it's called, Immigration Law Updates from Adam Pipe. So if you search in WhatsApp in the channels, Immigration Law Updates from Adam Pipe, it's a public channel and you should be able to join that, but I'll make sure the link is available to everybody. All right, so yeah, that's fine. Somebody says, when will the English language requirements come into force? As I said, no dates for anything at the moment, but I know Lucy and I were chatting in a previous call that I don't think some things are controversial and the government are going to have to consult with industry and it involves workforce sectors. But I think English language they could do in the next statement of immigration changes. We've only seen one rule change this year. They're usually sometimes doing in the summer, and then there's a big one in the autumn. I would watch for some of these instant changes coming in. So I think, and I'm not just saying this because we're on a Language Cert webinar, but I think English language is something that changes could come in quite quickly.
No, and that's very useful for people to know, in terms of advising their clients to, you know, ensure that they are, you know, pursuing language tuition if they need that. And then if they do feel that they have the right level, you know, using the practice materials and things that Ozzy mentioned, they can test themselves. They can, you know, complete a practice test and see see if they are at the level that they need to be, and if they're not, then they can take further action to gain language tuition before coming back and taking the test. So now's a good time to be making that assessment, and for people to be thinking where they are.
Yeah, I think it's not about panicking. It's about preparedness. So I think both in terms of advising clients what's likely to come. So for some people, it's about making applications now and think, right, let's make that application. I want to come to the UK as a care worker. I want to come to the UK as a student now. Let's make it. Or I'm going to qualify for a graduate visa. Let's do that now. For some people, it's thinking, well, I might want to bring my dependents in the future. Let's get them working on their English language skills now. I don't know whether there will be exemptions for those who in exceptional circumstances, because we know for family visas there are exemptions for certain categories of people, for medical or age, for example, reasons for the English language requirements, but it's something to start working on now. And for those who want to qualify for settlement earlier, I know it sounds crazy, but making sure if we're doing community work, getting good evidence of that, because ironically that might be something that will come in the future. So it's about making sure the information's out there. So hopefully I've given you in this session information you can disseminate amongst your networks to make sure people are aware. Then start to either make steps now, in terms of application, start preparing now, or if you're an educational institution or an employer, start auditing to plan the future so you can be planning what steps you need to maintain to protect your business. All right, so I hope that's helpful, Lucy.
That's excellent advice, thank you. Ozzy, did you have anything further to add?
No, I mean, I can only sort of echo what Adam is saying. It is very important as an immigration lawyer to be proactive and to share, what's going on. And in terms of English language proficiency, I think the first action I would do if I was an immigration lawyer would be to just know the current level of my client. What according to the Common European Framework. So if you have a client and is planning to apply, let's say, to any of those applications, they can easily take our test simulator to know what their level is actually. And it is a proper exam, and please do take advantage of those free preparation resources and know your client and know what the English proficiency level of your client is.
Yeah, fantastic. Well, I'm looking at the Q&A, and most of the comments are purely saying, thank you very much. It was extremely interesting, and we'd love to have the slides. So we'll make sure that everybody receives them. So thank you once again, Adam. That was fantastic. I certainly feel more knowledgeable than I was at the start of the webinar. And thank you to all of those of you who attended. It's great to have you with us, and I hope you have a lovely rest of your day. Thank you very much. That's the end of the webinar.
Thank you.
Thanks, guys.